Today's topic is land registration, focusing on overreaching and overriding. You can read the notes on this topic on SimpleStudying. However, now we are going to revise the key principles and address an essay question on this topic. Land registration. In English law, there may be a lot of third-party interests that could exist. For example, an interest arising from promissory estoppel, or a beneficial interest that the registered owners of the land were not aware of. So that's why the land registration system was created. So a new owner of the land who is purchasing the land knows exactly who is the legal owner of the land, as well as who is the beneficial owner of the land. If there is any charge of the land, it will appear on the charges register under the registration system, and that was the aim of the Land Registration Act 2002. Formalities covered under Section 2 LPA 1925. For conveyance of the land, contract must be in writing, all the agreed terms signed by all parties. Freehold. There are two types of ownership: freehold and leasehold. Freehold is always triggers registration. Whenever freehold title is conveyed to someone else, it has to be registered. Leasehold is only registrable if it's for more than 7 years. So if it's a lease, it doesn't have to be registered unless it's more than 7 years. Leasehold for over 3 years must be granted by deed. It must be in writing. Section 1 of the LPA 1989 states that an instrument is validly executed as a deed if it is signed with 2 witnesses who attest the signature and delivered as a deed. So witnesses are necessary under LPA 1989 for formality requirement to be satisfied. Overriding interest. Very often we get problem questions and essay questions on the exam about overriding and overreaching interest. And most of the time students confuse these two concepts because, well, the name is similar, but those are two different things. Overriding interests, LRA, Land Registration Act 2002, Schedule 3, Paragraph 2. Legal leases for 7 or less, which is not registrable, equitable interests such as actual occupation and implied legal easements or profits upon. Well, these are all the list of overriding interests. So they are capable of overriding someone else's interest, such as legal leases for 7 years or less that is not protected by registration, equitable interests such as actual occupation, and implied legal easements. Overreaching and overriding interests. You should have a look at section 28 and 29, which are relevant sections here of the Land Registration Act 2002 for the issue of priority. So basically you have different kinds of interests here in land. You could have actual occupation, you could have implied easement, you could have the profits. So basically the issue here is the priority. Which interest in land will take priority over the other? 2 methods of protecting interests in the land: by notice or restriction. So the notice can be entered in the land registration, or there can be a restriction on the land, not permanent or short-term. Very important case in this area, Baker versus Krug, 2016. When a purchase of the land is buying a property and paying at least 2 trustees, they would be overreaching interests. In this case, Mr. Krug's overriding interest, which was actual occupation, before we listed that actual occupation is one of the recognized overriding interests under the LRA. So Mr. Krug, in this case, had an overriding interest because he was in actual occupation of the property, and that was overreached by Baker's overreaching interest because they bought the property and paid 2 trustees. So basically what was happening in this house was that there was land and they were selling the land. Two people bought the land, and when they bought the land, they paid two trustees, therefore they had overriding interest. There was someone else, I think it was a neighbor, who was saying that he was in actual occupation of the land because I believe he was taking care of the land. He was saying that he was in actual occupation of the land, therefore he had an overriding interest. But the court said that because the land was sold and two trustees were paid, the overriding interest was overreached by the new purchasers of the property. So that's why the land registration exists. Even if someone has overriding interest, but someone buys that land and pays the trustees, those overriding interests will be overreached by the new owners of the land. Example essay question that you may get about land registration. Land registration system permitted the courts to protect significant proprietary rights, achieve certainty and fair outcome, critically analyze. This kind of example essay questions are very common, and I suggest that you practice answering this question with the guidance that I will provide now. Firstly, you should understand what the question is asking you. It's one of the most common mistakes that law students make, why they get low grades, is because they misunderstand the question. Most of the times when they see a question about Land Registration Act, what they do is they write everything they know about Land Registration Act, all the cases, without providing any arguments or any analysis. So that's, if you do that, most likely you will not be able to pass. It's not about how many cases you know. It's not about how well you understand the law or how many legal provisions you have memorized. No, it's about the quality of your arguments. You need to be able to provide analysis and arguments on both sides of the essay question and answer the question asked rather than write everything you know about the topic. Land registration system was amended by Land Registration Act 2002. It has to be compared with the previous system for the purposes of answering this question. You should argue if the new system is fair, more certain, and protects significant proprietary rights. So these are the three things you need to argue. Is it fair? Why? Why is it fair? And obviously, whatever you say, it has to be supported by case law, by statutes, by peer-reviewed journal articles. You could use online resources as well, but only if it's a reliable source. You cannot use anything like Wikipedia, but things like, for example, BBC or like reliable sources can be used as an online resource. But definitely, if you want to get a first class in an essay question, you should be using peer-reviewed journal articles for your arguments. In the introduction, you should not have anything more than just explain the relevant law. You are not putting any arguments in the introduction. Introduction should be by 10% of the essay. So, for example, if your essay is 1,000 words, your introduction would be 10% of it, which is maximum 100 words. In the introduction, you have to explain the relevant law. In this case, the relevant law is the question is asking about LRA 2002. Therefore, you need to explain what are the objectives of the LRA 2002. Obviously, you do not need to explain here all the provisions of the LRA 2002 because that's not relevant for the question asked. But the question is asking you about the objectives of the LRA. Therefore, you need to explain what are the objectives of LRA 2002. Briefly introduce the problems with land registration system. So the question here is asking you to critically analyze whether or not this LRA 2002, the new system, is more fair, certain, etc. So you need to briefly explain what are the problems with the land registration system. Why was this LRA passed? What was it supposed to solve? What problems was it supposed to solve? And thesis statement, announce the plan of the essay. Something like this. The present essay shall critically analyze if Land Registration Act 2002 has improved the protection of significant proprietary rights, as well as introduced a more certain and fairer system of property law. So the thesis statement should be announcing the plan of what you're going to argue in this essay. It has to be using the same vocabulary as the essay question itself, sometimes even repeating the essay question, some parts of it, because you have to make sure that the thesis statement matches with the question asked, because you have to answer the question asked. Arguments for and against based on legal authorities. As I said, you need arguments on both sides. Even if you agree strongly with one side of the argument, you have to always try to put your emotions aside with whatever essay question it is. It doesn't matter if it's land law or if it's another topic, whatever question it is, you should always argue from a neutral point of view. It's true for lawyers as well. When you become a lawyer, you have to argue neutrally, and you have to be able to provide arguments on both sides, even if you don't agree with it. So same here, you have to provide arguments for both sides. Therefore, the arguments that it's a fair system, that it's a certain system, or arguments that it is not a fair system or not a certain system. Show cases before and after LRA 2002 for contrast, and discuss if the outcome of the cases after 2002 shows more fair and more certain, a certain outcome, better protecting significant proprietary rights. But your arguments must be very, very clear. For clarity of arguments, I suggest that you use good transition words and small sentences. Let me explain. So transition words are the words that you use to link logically two sentences or paragraphs together. For example, moreover, furthermore, also, additionally, those are transition words to add a point. But when you are introducing a contrasting point, you should use another transition words such as however, nevertheless, by contrast, on the other hand, and so on. If you just Google transition words, you will find a lot of them. And I believe that you should be using a lot of transition words in your essay to be able to logically communicate the arguments and clarity of the arguments. For clarity of the arguments, it's also very important that you keep it short, keep the sentences short, concise, and simple words. Law is not about using sophisticated vocabulary that obscures the meaning of your argument. No, simple words is good, because the most important here is that you communicate a clear argument. For clear argument, law is complicated enough, and the examiner, you have to understand that professors are reading maybe like dozens of papers every day. And you should make sure that your arguments are easy and clear to understand. Otherwise, it will be hard for the examiners to understand what you're trying to argue here, and therefore you won't get points. So make sure that you communicate your arguments in a clear, concise, coherent manner. You will most likely not get a passing mark if you simply write every case you know about this topic without making clear arguments. You only mention cases that are relevant to the argument you're making. Your lecture probably on this topic will have many cases, but that doesn't mean that you are required to put all the cases that are also in the lecture. No, only the cases that are relevant to the essay question and to the argument that you're making. Example arguments for certainty. One of the example arguments, LRA 2002 modernized the land law. New conveyancing system preparing to transfer to e-conveyancing, simpler, more efficient, certain, cost-effective. It's more cost-effective version than it was before. It's cost-effective system. Equitable rights are easy to discover under the new registration system. Before this registration system, if there were equitable rights, someone could just bring an action against the new purchaser. So when someone bought a land or a house, and they were not able to see equitable rights because there was no land registration system like we have now, They wouldn't be able to discover the beneficial interests, and then someone who may have had a beneficial interest because of actual occupation or any other rights, they may have brought a claim, and then the new owner of the land will have to go to court and argue whether or not they have an overreaching interest. So that was a very inflexible system. This is more efficient. It's clearer who has a beneficial interest and whose interest will be overreached upon sale of the land. Therefore, it reduces the cost of litigation, both for the court and for the parties involved in the case. New purchase is protected by overreaching the equitable rights upon the purchase. Insurance principle, expanding the indemnity provisions to avoid fraud. So there are new the insurance principle that was added to expand the indemnity provision and avoid fraud. Those are all example arguments. Explain what was the main purpose of LRA and to what extent it has been achieved. Ensuring the registered owners of a property acquire a good title and every possible claim over the property are overreached upon the purchase of the property. Explain how overriding and overreaching works under the new system and if it's fairer and more certain system than before. So you need to explain what are possible reasons why overriding and overreaching works better than in the new system, better than it was before. Well, one of the biggest arguments here is that it's more certain for the new owners of the land and they are protected. So when someone buys the land, they are protected, that nobody will be able to have a better title over the land than them because they just bought the property. They want to have the highest title. Fairer system for registered owners. Before, for registered owners may have been challenged in court for ownership by someone who had who may have had a beneficial interest in the land. Right now, with the new registration system, it's a lot fairer, and registered owners are a lot more protected than before. And you can have a look at cases. However, if interests in land are not registered, it will most likely be overreached upon the sale of the property. Important cases that you need to take a look: Baker versus Cracks, Chaka, Mortgage Express versus Lambert, Chodari. We have case summaries that you can have a look, as well as our notes. You should take a look at our notes. It's a great summary of all the main principles that you need to know about this topic.